Hi, this is Kristen Armstrong, and I am back today to talk to you a little bit about in-home care, and specifically what is needed when you apply for Medicaid to show that you were receiving in-home care and that you were making payments for in-home care. I also am going to talk a little bit about VA benefits. There are veterans benefits out there for certain veterans who are receiving in-home care. And so I want to talk to you a little bit about that because there can be some interplay between veterans benefits and Medicaid benefits as well. So I'm going to talk to you a little bit about that today. And I'm going to share my screen and pull this up. Give me just a moment here. All right, so in-home care, caregivers benefits and veterans benefits. Here we go. Again, my name is Kristen Armstrong. I'm an elder law attorney in South Central Kansas. I serve clients in Central and Western Kansas, including Reno, Sedgwick, Marion, Butler, Kingman, Saline, Dickinson, Finney, Ford, Rice, and Lyons counties. I'm sure there are also a few others out there that I'm forgetting to mention, so forgive me for my clients out there that live in a county that I have not mentioned. Our firm also, of course, has clients in Overland Park and the Kansas City metro area and more of Eastern Kansas and Western Missouri. Our office locations for Shepherd Elder Law, again, I'm here in Hutchinson in Central Kansas. We've got an Overland Park, Kansas location located in Corporate Woods, and we also have a Northland, Kansas City office as well. So talking a little bit about care contracts, what do I mean by a care contract? I mean something formalized in writing that says that the person who is providing care is entitled to receive X number of dollars. And there are a variety of things that need to go into a care contract that an elder law attorney can assist you with. The care contracts for veterans benefits and for Medicaid benefits are sometimes different. So there are things that can be in a care contract for that would be approved by Medicaid that would not necessarily be approved by the VA. So it's not as simple as just putting something in writing and saying, I agree to pay so-and-so for the care that's provided. It's a little more detailed than that. So give us a call if you are somebody who finds yourself, after listening to this presentation, if you find yourself in need of such a care contract, give us a call and we'd be able to help you out as part of the estate plan. So when applying for Medicaid, you must disclose any gifts that have been made within the last 5 years. Medicaid is entitled to receive and to request and to review up to 60 months of financial statements. So again, 5 years worth of financial statements could be scrutinized. Within those statements, Medicaid will look for transfers to individuals, including any checks and just other banking transfers, basically within the same bank or going out to other financial institutions. And they'll also look for large cash withdrawals as well. And they'll ask where the cash went as well. There is a presumption that when you are transferring money or when you've written a check to a family member or to a friend or an individual, that it was a gift. And unless there's something in writing showing that it was not a gift, for example, if you have a care contract in place, showing that it's not a gift and that it is actually money that was earned and entitled to be paid or required to be paid for those services, then, like I said, there is a presumption, and Medicaid is going to presume that those were gifts and that it was not money that was earned. So an example of this would be that maybe sister and brother or rather, son and daughter are providing in-home care to mom because dad's passed away and mom's just having some trouble getting around the house. So she needs some assistance with housekeeping, with meal preparation, maybe remembering when to take her medicine. Maybe she's a fall risk and she needs somebody to be at home when she takes a shower. And those kinds of things. So if we're paying our son or our daughter to take care of those, or anyone else for that matter, but but in this example, son or daughter are coming over and doing those things. If we're paying them $10 an hour, for example, $20 an hour, then there needs to be something in writing showing that they are getting paid for those services and that you're not just giving them money to quote unquote help them out. Payments to non-relatives and businesses. There was a recent rule change in Kansas that requires that even if you hire an outside company, so there's lots of companies out there that are angels or in-home caregivers that are non-relatives or non-friends. It's actually a company that's coming in. You have to have the paperwork. You have to have a contract in place showing that you are paying them for care. It's not just a presumption now that because it's a business that you're paying them for care. You actually have to provide a copy of that contract, and that contract needs to go back to the date of when the payments first started, because anything before that is going to be deemed a gift and therefore would be penalized, meaning Medicaid is not going to pay for any care in the nursing home or any in-home care or assisted living care for any period of time related to basically what happens is if you've given away $5,000 or maybe you've had $5,000 worth of care services, but you cannot show that you had a contract, Medicaid's not going to pay about $5,000 worth of your care. So then when you go into the home, you've got to come up with $5,000 to pay for that care before Medicaid will kick in. There are some veterans benefits out there for in-home care. And again, I mentioned you need to have a care contract in place with these. And it would be best to have a care contract in place because frequently, like I said, there's some interplay between veterans benefits and Medicaid benefits, especially when we're talking about in-home care or assisted living. The veterans benefits, we have to meet 4 criteria. We have to have a wartime service requirement. Okay, we have to be medically needy, and we have to be financially eligible. That wartime service, and the 4th one is that you have to be discharged other than dishonorably. So you can be medically discharged or honorably discharged or other things, but just not dishonorably discharged. The wartime service requirements, we've got some World War II vets who are still out there and still alive. So World War II, Korean War, Vietnam War, and then ongoing wars since then actually qualify as well, Iraq War and so on. You have to be medically needy, meaning that you need assistance with 2 activities of daily living, 2 or more activities of daily living, or that you're blind or that you have cognitive impairment. And you also have to be financially eligible, and that is also where an elder law attorney can assist you with applying for those VA benefits or actually becoming eligible for those VA benefits financially. The maximum VA benefit for aid and attendance for a married veteran is a little over $2,200 a month. If you're a single veteran, it's about $1,900 a month. And if you are a surviving spouse of a veteran, never divorced from the veteran, I should say, it's about $1,200, almost $1,300 a month. That's the maximum benefit that somebody could receive. Again, this benefit here, $2,266 a month for married veteran, that would be to help pay for in-home caregivers, including the children. No experience is required. If the kids are assisting with those household activities of daily living, they are entitled to be paid, and the VA would actually pay them for that or reimburse you for payments that you are paying them. Also for in-home care. So in-home care, also for assisted living, and then also for long-term care and nursing home and such. And that's the end of my presentation today. Again, if you have any questions or you find yourself in need of a care contract or would like to discuss veterans benefits a little bit more, please give us a call. We would be happy to help.